Welcome everybody to MidShires' first webinar. So it's a first for MidShires and a first for me. So welcome all MidShires members and guests, and I'm sure you'll find this evening webinar very, very useful. Just to update you on branch meetings, I suppose it goes without saying that the meetings at the hotel venue are postponed until further notice, but I will keep you informed on progress with that. The AGM has also been postponed. That was due in May, but now that's been postponed till further notice. Again, I will keep you posted on that. The current committee, bless them, have all agreed to carry on until further notice, so I thank them for their support with that. You'll see on the slide, I've put a couple of links there for you, IOSH COVID-19 resources. The bottom one, there's been weekly webinars. There was one last Thursday and one today, but they're going to continue on a weekly basis for the forthcoming. So please keep an eye on that. Certainly I was on the one last week and it was absolutely brilliant, so well worth making a note of those links. Okay, speakers tonight are Hayley, Saunders and Hannah Frost from Shoesmiths. Hayley is a specialist regulatory criminal defence lawyer advising leading companies, directors and individuals on all aspects of regulatory compliance across a range of sectors including retail, food, manufacturing and construction. Hannah is a solicitor in the regulatory team at Shoesmiths and regularly advises companies, directors and individuals on regulatory compliance across a range of sectors including health and safety, food safety, product safety and fire safety. So without further ado, I'd like to hand over to Hayley and Hannah. Thank you very much.
Thank you, Roger. Hi everyone, or good evening. It's Hayley here. Obviously a slightly different setup to how we normally are, which will take some getting used to, but I'm sure as we are all very good at adapting to change, we'll all be fine. I'm grateful there's no video. Had I known that for longer than about 5 minutes, I probably would have gone and got a cold beer to sit here and enjoy doing this at the same time, but I haven't, so I can't blame being drunk on a bad presentation, I'm afraid. The bonus as well is that I can't hear everybody, so in my head I think everybody's laughing at my rubbish jokes, but at least you don't have to pretend to laugh this time. So I can't believe it's been another year since we were here last time. Hannah's kindly joined me this year. Hannah's a solicitor in our team, and she kindly put the slides together for me, so it's only right that she presents them with me. I did check to see if she had anywhere else to be this evening, but luckily she didn't. So in terms of the next hour or so, I don't think we'll take an hour. You'll be pleased to know, as I'm sure, even if you've got nowhere else to go, you've probably got a better room in the house to go and sit in this evening. So in terms of the update, I expect we'll probably be sort of half an hour, 40 minutes max perhaps, and then any questions afterwards. But I would have thought we'll all definitely be away by 7:30 at the latest. In terms of what we're going to go through, it will be our normal format that we'll look at in relation to this legal update. So Hannah's going to cover some statistics and the key developments that have happened over the last year. I'll then have a look at some recent and notable cases, and obviously we'll have to touch on coronavirus. Sadly, it's obviously been occupying all of our time for the last few weeks, and it's obviously brought about some legislative change which we'll go through. So I'll cover some of that, and then Hannah will pick up on what's on the horizon for the next year. So I'll pass over to Hannah for the statistics and the key developments from last year, and then I'll carry on with some of the cases.
Thanks, Hayley. Hi, everyone. So just to start off with, like Hayley said, just going to look through the latest statistics from the HSE this year and just do a bit of a comparison to last year as well, just so we can see kind of where we're at in terms of injuries at work and then also the enforcement figures as well. So you'll see there on the first slide, this focuses on kind of injuries at work. So First point, 1.4 million working people suffering from work-related illness is largely at the same level from last year. Deaths at work, unfortunately, are slightly up. It was 144 last year, 147 this time round. In terms of injuries that occurred at work, there is an increase this year compared to 2018. So there's 45,000 more injuries at work this year. In terms of those injuries that were reported under RIDDOR, though, they are less than last year. So last year it was 71,602. So a slight decrease there. Working days lost as well, also down by about 2 million. But they haven't updated the cost of injuries yet, as far as we can see. So it's still at that 15 billion figure as a guide. The latest figures show kind of obviously why the HSE are focused on reducing these numbers as much as possible, because there's increases in certain areas, but I think generally there's a stable and kind of a downward trend with no particular spikes to be like concerned with. Just like kind of on a general note as well, the UK consistently has one of the lowest standardised rates of fatal injury across the EU, so much lower than other large economies and the EU average. So even though like some of these figures are pretty high, generally the UK is good for health and safety. So then in terms of the enforcement statistics, the number of notices is down slightly by a couple of thousand this year. But again, kind of not enough to be really notable, so generally a stable trend. The convictions have fallen as well, so they were 493 last year versus 304 this year. The conviction rate last year was 95% versus 92% this year. So again, like decreases that we're seeing in certain areas, but not major decreases. Total fines as well have reduced by about 15 million. And while it's obviously a significant sum, the fact that we're seeing total fines at a level of over 50 million per year shows the impact of the guidelines that came in 2016, because it's obviously quite a significant figure. And yeah, fines remain in the most common penalty. And then just a note at the end of the slide about the kind of following convictions for individuals suspended in immediate custodial sentences as well in a small percentage of cases, but quite significant for obviously 9% on 3% of those cases that were impacted by that. So next I'll run through some key developments of the last year or so. As you all know, I think it's fair to say that Brexit took up a large amount of the parliamentary time last year, and so this kind of flows into this legal update, and meaning that there wasn't much new legislation produced last year. There was probably 3 main changes that I'll run through, and then a couple of more sector specific updates from the HSE that I'll go through quickly as well. So the first one, I mentioned it just then, is can't kind of do a legal update briefing based on last year without mentioning Brexit. So it was a major development of the last year, and the UK officially left the EU on the 31st of January 2020. We're now in the transition period, which began immediately after that Brexit day and is due to end on the 31st of December. During this 11-month period, the UK will continue to follow all of the EU's rules. So businesses' duties to protect the health and safety of those affected by their work will not have changed. There have been some minor amendments to remove references to the EU from certain regulations that kind of were derived from EU law originally, but the approach from the UK government is to bring all existing EU law into UK law. So for now, the legal requirements for employers from a health and safety perspective remain the same. The European Union Withdrawal Act 2020 received royal assent on the 23rd of January and has been passed into law. That implements the agreement made between the UK and the EU, but there obviously remains to be seen how the rest of the negotiations play out. But at the moment, from a kind of health and safety duties perspective, the status quo is maintained. So the second topic kind of dominating the news last year would have been the Grenfell Tower public inquiry, which concerns obviously the tragic fire that occurred in June 2017. In terms of where they're up to so far, phase 1 of the inquiry has completed, which focused on the events of the night of the fire, and a full report was published in October. The report for phase 1 mainly defers findings and recommendations until the end of phase 2, which is kind of ongoing now. But we are starting to see some changes to fire safety legislation and building regulations, which I'll come on to. In terms of what's happening now to the inquiry, it's been suspended for the foreseeable future, understandably, after obviously the tightened restrictions on social distancing, because it was gathering a large number of people in a room, including vulnerable people as well. Prior to the suspension, phase 2 was underway, and they were calling witnesses involved with the refurbishment of the tower, those that were involved in installing the cladding, and members of the council. So phase 2 is seeking to identify how and why the building failed in the way that it did. These hearings for phase 2 now, with the delays, are likely to conclude sometime in 2021, and the final report will follow from there. In terms of enforcement action arising out of the inquiry, the Met Police have been running their investigation alongside the inquiry, and they announced that so far they've conducted 17 interviews under caution as part of their investigation. The interviews were for gross negligence manslaughter, corporate manslaughter, and health and safety offences. But they've said it wouldn't be right to bring any charges before the kind of final report from the inquiry has been published. So we're not expecting to see any major developments in the police investigations until then. As well, just like the last point on the slide there, so there's also a group called the Grenfell Task Force that have recently published a report. They are kind of concerned with rehousing and providing support to the survivors and bereaved at the tower. They permanently rehomed 95% of survivors, but state that there's kind of still some way to go before they achieve what they set out to do in terms of the support to those that's obviously lost their homes and family members. Kind of like nearly 3 years on from the fire, there's still some work to do. So yes, as mentioned on the last slide, even though we're still waiting for the end of phase 2 of the inquiry and the recommendations from the chairman there, we are starting to see some updates to fire safety coming through. The fire safety bill was introduced to the House of Commons in March 2020, and its purpose really was to clarify some of the points in the regulatory reform fire safety order. It applies to the external walls of the building, so that's obviously including the cladding, the balconies, the windows, and also individual flat entrance doors in multi-occupied residential buildings. These changes that come through in the fire safety bill will be of most interest to kind of building owners, leaseholders, and managers for multi-occupied residential buildings, because those people are likely to be the responsible people who need to ensure that they assess the fire safety risks really of the premises for which they're responsible and make sure that they're in line with the new updates. The bill itself will also kind of confirm and update enforcement powers of the relevant fire rescue authorities to hold owners or managers to account, so there'll be enforcement powers in that as well. Then probably in terms of kind of legal news of last year, the third topic dominating the news from that perspective would have been allergen labelling, and so high profile fatalities and serious incidents relating to the absence of allergen information. I've certainly known as a consumer and a lawyer kind of increased focus on allergen labelling requirements, both kind of going to restaurants and food outlets, but then also in terms of advising clients facing enforcement action as well. So one of the changes arising out of this increased focus is the food information amendment regulations, which have been introduced. So these relate to food that's pre-packed for direct sale. And just for clarity, food that's pre-packed for direct sale refers to food that's made on the same premises as it's sold. So kind of obviously the obvious example here would be the sandwiches in Pret. That was one of the major high profile cases. So the regulations themselves follow a joint consultation run by the Food Standards Agency and DEFRA earlier in the year. Just click to the next slide. The changes themselves apply from the 1st of October 2021 even. And food that's pre-packed for direct sale will need to have the following information displayed on the packaging. So the name of the food, the full ingredient, and the allergenic ingredients emphasised. That's obviously the case now, so by October 2021 that will need to be implemented. if the regulations are likely to affect like any of your clients or the business that you work for, you'll need to ensure that your allergen procedures and labelling is updated to meet the requirements of the new regulations. In terms of guidance to accompany the legislation, which is kind of what we would look for our clients to help them and to help businesses comply, there isn't any as yet, but the FSA have launched a consultation which closed in early March about how to present this guidance. So we're just awaiting the outcome of that consultation. Then in terms of kind of the more specific HSE updates that just relate to certain sectors, there's a couple to run through. In January, the HSE published a revised version of EH 40/2005, which detailed new revised workplace exposure limits for 13 carcinogenic substances introduced by the Carcinogens and Mutagens Directive 2017. So it will guide those responsible for controlling exposure to hazardous substances at work. So these revised limits may mean that you need to review your COSH risk assessments to ensure that exposure for the 13 substances listed is controlled to as low as reasonably practicable. And yeah, so I'd refer to the guidance for the new entries because they're quite difficult to pronounce, and I wouldn't want to mess it up. So it's on the HSE website. You can have a look there. Then just another HSE development. So at the start of the year, the HSE announced that they would be inspecting sites across the country which carry out metal fabrication work to check that employers are controlling exposure to welding fumes and metalwork fluids. And the HSE has now revised its COSH direct advice for welding, which employers in the relevant industry should familiarise themselves with if they work in this sector, to make sure their business complies with the new guidance. So that is it from me in terms of key developments of last year, and I'll hand over to Hayley now for some case law.
Thanks, Hannah. You'll have to be my lovely assistant and move me on each slide.
Yes, I will click. Shall I click to the next one?
I feel like one of the medical advisors at the 5 o'clock Downing Street update asking for the next slide. Thank you. Yeah, so, sorry, in terms of cases that have come through the courts this year, as you would expect, there's been, obviously we're now, 4 years into the Health and Safety Sentencing Guideline document, which is obviously the document that courts use when handing down fines. So that's where we went from the world of relatively low level fines to fines that are reaching the millions. So again, most of the cases go through, there'll be lots and lots of cases where there are, high figures in terms of the level of financial penalty, but that's becoming the norm now. So we haven't necessarily reported on those. What we have just referred to are some of the cases which just have the principles from them that relate to the guidelines. So this one, for example, in fact, I think we would have included this in the case law update from last year. It's the prosecution of Bupa Care Homes Limited. They were fined £3 million following the death of an 86-year-old resident at a care home in Essex from Legionnaire's disease. They couldn't actually link the actual cause of death to the Legionella at the care home, but they did prosecute the company for failing to implement the control and monitoring measures required to safely manage the hot and cold water systems in the home. So they were fined £3 million. They were ordered to pay quite a significant amount in costs, about £150,000 in costs. So it was one of the highest fines last year when this was sentenced, and the court took into account the financial circumstances of its parent company, Bupa Limited. So the relevant entity that was being prosecuted was Bupa Care Homes, a subsidiary of the parent company, Bupa Limited. And you may recall from the sentencing guidelines that you can only take into account the finances of a parent company in exceptional circumstances. And there's the Whirlpool and the Tata Steel cases where they were wholly owned subsidiaries of the parent companies, but they were companies that were classed as a going concern, and they were being financially propped up by the parent, and therefore it was right for the courts to take into account the finances and the accounts of the parent company. Whereas in this case, it went to the Court of Appeal earlier this year, and the fine was reduced from 3 million to 1.5 million, and the Court of Appeal said that the sentencing court was wrong to take into account the financial circumstances of the parent company. There weren't the sufficient grounds, as there were in Tata Steel and Whirlpool, for them to do that. So they reduced that fine on appeal to 1.5 million. Next slide, please. Okay, so prosecution here, Clancy Dockwra, in August of last year. So this is a company with a turnover of 264 million. It was a prosecution of both the company and a site supervisor following the death of an employee who was struck by an excavator. Neither the company nor the individual site supervisor pleaded guilty. They both went to trial, and they were found guilty at trial by a jury. The company was prosecuted for Section 2, general duty to employee, and the site supervisor was prosecuted under Section 7, the general duty of employees to everybody else. So interesting again, and this is something that we're seeing more of in terms of individual prosecutions. So again, the likes of a company the size of Clancy Dockwra, you perhaps normally expect to see in the dock on their own, but in these circumstances, the HSE could levy liability at the level of the site supervisor at employee level, and they prosecuted both. And the company were fined £1 million, and the site supervisor was given a 6-month custodial sentence, which was suspended for 12 months and ordered to pay costs of 15,000. Next one, please. DHL. Again, it's not the same slides from last year, although you could be forgiven for thinking that they are, because some of you will probably know that DHL had a previous prosecution. This accident's in relation to an employee that was killed, along with a number of other employees who were injured following the collapse of a stack of tyres at a warehouse. And DHL had allowed high and top heavy stacking of tyre containers right next to an office. The HC's or the local environmental health investigation revealed that this was a dangerous practice. It had become commonplace amongst its staff, and the staff were never told not to do it. And the court were told by DHL, who had taken over the site recently, only a few months before, they'd taken over the site from another company. So you can imagine the legal submissions that would have been put forward, I'm sure, in relation to, they would have trooped across a number of staff, taken on a new company, and as you guys know, along with that comes a number of issues in terms of cultural differences, and they were probably trying to get their house in order, which would ordinarily be relatively good mitigation. They were criticised, though, in that DHL had failed to carry out any type of health and safety audit, which could have helped identify and therefore remove any poor practice. Again, I know it takes time, and it takes a long time to change a culture, but the fact that there hadn't even been an audit of any type in relation to health and safety didn't go down with the court very well. They have their previous health and safety record. In 2018, DHL were fined £2 million for health and safety breaches after a 36-year-old man was crushed to death by a lorry that was reversing at its depot in Milton Keynes. And this time round, they were fined 2.6 million in respect of this incident, and their turnover is 1.4 billion. So again, the fine has increased on the fine they had received last time, which would have, without a doubt, have been an aggravating feature to this offence. Next one. Another recent large fine. Not anything particularly groundbreaking here with this one, just the fact that it's Tesco with a large turnover, 42.22 billion. So in terms of very large organisation, when it comes to the financial turnover that's specified in the sentencing guidelines, you can clearly see that Tesco well and truly meet that criteria. They were prosecuted, it was in relation to a 91-year-old customer who'd slipped on some water that was leaking from refrigerator units. He fell and suffered multiple injuries, hip fractures. The leaks hadn't been able to drain away because of a blockage in the drains under the floor, which was caused by some bacteria. And this problem had arisen elsewhere in the store and had been fixed by making holes into the floor. So it showed that they'd been aware of the risks for some time, but they hadn't managed to effectively mitigate it. So a large fine, you can see by the 333.333, the starting point would have been £1 million, with the reduction of 1/3 for the early guilty plea. Next one. Just 2 or 3 cases coming up in terms of cases of interest, really, just going back to this point that, again, you know, not just us, when we speak in the industry to other health and safety lawyers, we can see that there's a number of prosecutions against individuals, and that could be individuals that are prosecuted alongside the company that they work for, or the company they're a director of, or it could just be them on their own where the company's not being prosecuted. That was the case in this one. So a former director of the company, they could see that he was the person that was responsible, he was the person that was in control of the site. It was in relation to unsafe working at height, which you can see from the regulations of the work at height regs that he was charged with. And then section 22, there was a failure, there was a number of prohibition notices served by the HSE, who had obviously ordered that the work stop until they're safe to resume again if the work at height issues had been addressed. He ignored those prohibition notices and therefore acted contrary to them and in breach of the notices, so he was prosecuted for failing to comply with those. He pleaded guilty to both of them, sentenced to 8 months imprisonment, which was suspended for 2 years, and then a chunky amount of community service there as well that you can see. So again, you know, we are seeing a lot of cases where directors and individuals are going to prison for these offences. Again, we are seeing a number of those prison sentences being suspended, which is what we saw pre-guideline, but this might have been a case, for example, where ordinarily community service sentence may have sufficed. I mean, it's slightly different in that you've got a complete flagrant breach here and disregard for the law, in that he's ignored the prohibition notices. But again, with the cases that we're seeing, it's less likely that individuals can avoid prison at the moment. Next one. Again, another prosecution of an individual. The company was prosecuted as well, along with its director, James McCoubrey. The prosecution was for a failure to conduct an adequate risk assessment to identify asbestos within the premises, and they'd been told to stop work as soon as asbestos was discovered, and the director carried on with the asbestos removal works, which is why there's the failure to comply with the prohibition notice. It is a Scottish case. It's not a Scottish case at all. It's a Northern Irish case, as I can see there from the legislation. Again, in terms of how the sentencing guidelines are applied, they don't strictly apply to Northern Irish law, but the courts do tend to follow the principles that are coming from them. Again, the same with Scotland, in that they don't strictly apply to Scottish health and safety cases, but again, the courts are taking the spirit of the guidelines when they're sentencing these health and safety cases. And then next one, the final one, again, just another example. Sadly, another fatal accident to an employee who was crushed by an excavator bucket. It was being operated by the sole director of this company. There were a number of failings that the HSE found here. The director had failed to undertake a sufficient risk assessment, failed to give adequate instruction to those that worked with him, hadn't received the appropriate training or certification for operating the excavator, a number of failings, and he was given a 10-month custodial sentence, and that wasn't suspended, so he went straight to prison for that. So again, it just seeks to highlight again that the HSE are focusing on individuals, and sometimes instead of the company. Next one. Okay, wow, so what a few weeks we've had. Last year, obviously, all of the focus was on Brexit, and now that, you know, you can't quite imagine where we've come from last year to where we are this year or this week even. We've obviously gone from Brexit, and sadly this year we do really have something to worry about, and I think everybody will agree that the outbreak of coronavirus has brought with it unprecedented changes to the way we live and work as a society, and obviously the country's health and safety is definitely at the forefront of our minds now. So in terms of dealing with this from our perspective, the UK government and how it's responded to the pandemic, it's had to obviously bring in to force a number of pieces of emergency legislation, and some of that has included a relaxation of some of the rules, for example in relation to chemical manufacturing. A number of manufacturers that wouldn't necessarily manufacture chemical products, obviously wanting to do their best to help the nation beat this virus, have wanted to, you know, manufacture as much as they can sanitizer, various other chemical products that will help the NHS and the industry at large. Driver's hours, for example, the rules around those have been relaxed. Again, it's all very much, you know, the focus is it has to be an absolute necessity. You know, this isn't the opportunity for employers to take their foot off the pedal and relax any rules in relation to health and safety, especially where we do see specific relaxation of rules such as driver hours. You know, this isn't an opportunity to exploit any employees to be working beyond hours than they should ordinarily be. So we've all had a really busy week advising on the new legislation. I was lucky enough, I had a sabbatical earlier this year, so I had the first 3 months of the year off and went to do some travelling in South America, which sadly got cut short because of this. So I came back early, and this is the first few days I've been back. And as you would expect, every day has been advising on the new legislation. And in some respects, it's nice to look at freshly drafted legislation and interpret it for the first time, rather than old pieces of legislation that's had its edges nibbled around for years by various different lawyers. But equally, you know, there's lots of issues for us as lawyers to consider, lots for you guys as safety professionals to consider. And I think we'll all agree that we're all trying to help each other find our way through this difficult and challenging time. The world seems to change every day. The guidance seems to change every day. What we were revising yesterday has probably changed to a certain extent today. It's very fast moving times, and we're, as I'm sure you are, trying to help our clients as best we can. There's lots and lots of information out there. I'm sure you don't need me to tell you. You'll know the relevant websites to go to. I saw that Roger put up the information about the IOSH guidance. Naturally, as you would expect, the HSE and other regulators such as the CQC have issued lots of sector-specific guidance on their websites, which again, I'm sure you're familiar with. And obviously there's the gov.uk guidance, which has been issued and is probably well known by us all. But how it all interacts with the workplace and how we can continue to try and, you know, maintain businesses and maintain the economy as best we can is really interesting. Naturally, we're seeing a lot of companies that are concerned about how they operate in this new world and the additional legal liability that they may be taking on from a civil perspective and from a criminal perspective. So we'll have a look at a couple of those issues. As I say, there's been a number of issues that we've looked at this week. If anybody has specific questions, then pop them on the Q&A and we'll do our best to answer them. If not, you know, we can pick them up offline perhaps next week. So what are the HSE up to? Obviously, clearly their advice is the same as the government advice. You obviously stay at home and you only go out if necessary, and their inspectors are following that advice and they are staying at home. So they are saying that they are suspending the targeted inspections that you would normally have on, you know, construction sites, where they would come around and carry out their routine inspections. They're suspending those for the time being. They've paused their offshore oil and gas and onshore chemical explosives and microbiological industry inspection activities. They say they're going to continue to monitor them remotely, which I'm sure they can do to a certain extent, but it's obviously difficult because they can't get onto site to carry out the more routine stuff. They're going to do their best to undertake regulatory activities where they can, where they don't require site visits. They're going to try and do that as normally as possible. So approvals and authorisations for biocides and pesticides. And again, we've seen some of this in terms of manufacturers who have capacity to make products such as hand sanitisers, but obviously also need to go through the various loopholes to get the various permissions and the licenses. Some of the team have been assisting manufacturers with that. So again, the HSE, whilst working remotely, have been helping. They will continue to investigate work-related deaths to the extent that they can, and obviously the major serious injuries and dangerous occurrences. The extent to which they can do that remotely, I would imagine, is very difficult, and I'm sure they'll just have to assess each matter on a case-by-case basis as to whether they go on to site. And obviously if they go on to site, then they will follow the guidelines around social distancing. They have issued a statement in terms of their position that they're going to take in relation to health and safety enforcement. So they have publicly stated that they will take a flexible and proportionate approach to health and safety enforcement, which is interesting. I mean, you would obviously always hope that the HSE take a proportionate and flexible approach, but in these times where they can see that there are a number of challenges that businesses are facing and how they deal with those risks, I would like to think that they do approach that in a flexible and reasonable manner. That is what they've said publicly. Some clients have said to us, are they now condoning the fact that they're not going to come out onto construction sites? Are they condoning a relaxation of the rules? Which, no, of course, they're never ever going to say that, and they're never going to publicly make that statement. They will say that there's an obligation on employers, more so than ever, in relation to health and safety, and you have to clearly do all that's reasonably practical to protect your employees. Now, I appreciate it's completely different in terms of, and difficult how you do that at the moment, because of the current situation, but that is their position. And as I say, they will take this proportionate approach, but they will investigate, and I'm sure there'll be investigations afterwards, especially if you're getting employees that whistleblow to the HSE to say, look, our employer is not following the rules. So from an employer company perspective, you've got to do all that you can to comply, but I appreciate that's certainly not without its challenges. Next slide. RIDDOR. Again, interesting. So the HSE has said that you would only make a report under RIDDOR in those two circumstances, which is quite interesting. I mean, often whenever I get asked a question about RIDDOR, I always find it useful to go back to the legislation and the regulations to understand specifically those injuries or incidents that have occurred as a result of the workplace. And I would imagine we're not going to see a massive amount of RIDDOR reports simply because of the guidance that's been issued. I think obviously in terms of frontline workers, those in the healthcare industry, I think that's going to be more relevant. And one of the examples the HSE have given on their website in relation to exposure to a biological agent, which they are saying is the virus, is a healthcare professional who is diagnosed with coronavirus after treating patients with coronavirus, and obviously it's their job to treat them. So the HSE is saying that would be a reportable injury. Now again, the extent to which the HSE are going to investigate all of these is to be seen, and it will be interesting to see. I think the problem with coronavirus is it's so difficult to make that causal link back to the workplace. In some cases it may be easy, but because we all know how easy it is to pick up the virus, we have no idea whether it's as a result of the workplace or as a result of trying to attempt to do a weekly shop at a nearby supermarket. So I think there's going to need to be some flexibility. I guess if anybody's ever in doubt, then the best thing to do is to report, so as to not face allegations of breaching the regulations. But I think there's certainly a lot of room for interpretation in relation to what should be reported, which I think will just need to be done on a case-by-case basis. Next one. Yeah, so in terms of, one thing we're saying to clients at the moment is, it has to be based on a risk assessment. More so than ever, we always talk about the need to do risk assessments and it being the cornerstone of everything we do, but more than ever we need to ensure that risk assessments are specific and are definitely not seen as a tick box exercise. This can never be a generic document, and it's going to change. It's going to be fluid. The situation is swiftly changing, so we need to closely monitor what's happening and make sure those risk assessments are changed in accordance with where we find ourselves with the change in guidance and what we're going to face over the coming weeks in terms of the return from lockdown. It's the message there at the bottom where we're saying act responsibly and ethically. It's really hard. Companies want to do the right thing. They want to help and do all that they can to beat this pandemic. And it's trying to do everything, in terms of a safety perspective, doing all that's reasonably practical based on that government advice and that ever-changing situation that you're finding yourself in. And as long as we continue to do the right thing, as long as companies are continuing to do the right thing and not exploiting the relaxation of rules in any way, then I would like to think that we will get through this and companies will get through it without the intervention from the HSE. But I think one thing that is important in terms of communicating with employees, because that's part of the biggest risk factor, that these employees will go to social media or the HSE and report things that they're not happy with. But if they see an employer that is doing all that it can to comply with the guidelines and is heavily sort of enforcing that and reinforcing that through supervision and management, then you would like to see that they will take a different view and they won't go to the HSE and they won't go to the media, because they can see that their employer is communicating with them to do the best they can. So yeah, it's acting morally and ethically responsibly. Next one. I mentioned it earlier, there's a number of documents and guidance documents out there, depending on what industry or sector in which you're operating. As I said, businesses will be concerned about taking on additional liability. It comes back to doing all that's reasonably practical, includes following the relevant guidance to the extent that you can, and it's just going to vary so much on your business and what it is that you do. And quite a lot of our advice has been quite specific this week, and it's having to really think through the issues with various stakeholders within the organisation. And we all know it's difficult. We know it's really difficult to comply with the guidance, but we have to do the best we can. Next one. Home workers, again, you guys will know this, the extent to which you can work at home, then obviously you will be. Just a few other things to consider, things like DSE assessments. Gosh, we would worry about them with, the odd employee that works from home sporadically once a month perhaps, but it's just staying in touch with employees, and we know that they're working from home, and we know that the mental health side of things is going to have a real impact. So making sure, again, it's back to the communication part of it, in that making sure employees understand A, what's expected of them, but B, what you can offer them in terms of support as a company, checking in on them. Even companies that have been, employees that have been placed on furlough, it's really important to stay in touch with them and offer them the reassurance as best you can. And again, there's various guidance documents on the HSE website, and as I say, I'm sure you'll be aware of all of the guidance documents that are out there, but they're just some of the things to consider when you have got people that are working from home. Next one. Yeah, and then just lastly, in terms of sector guidance. So if you're, you know, in the care industry, you are definitely high risk at the moment. Companies that are facing issues in relation to PPE and not being able to get it, it's causing problems. There's specific assistance on the CQC website in relation to those types of issues and how you can get PPE. I appreciate that then flows into logistics issues of how you can then get the PPE delivered to you, but there are numbers on there to call and various options and measures that you can take to make sure that staff have the relevant PPE. Construction, again, there's been a lot of sort of public debate about key workers and what might be essential work or not. So obviously with key workers, those that are essential to continue to go to work, they have the option of, if they have children, to put them into schools, and the schools will stay open for them. Whereas you've got other workers who, so obviously the message at the moment is, if you can work from home, great, that's what you need to do. If you can't work from home, then you can still go to work. Obviously you have to follow the guidance, but the difficulty is those people who can't work from home and need to go to work then can't, because their children are at home with them, because they're not classed as a key worker. So there has been a lot of issues in relation to what's an essential business and what isn't. And you will have seen that the construction industry hasn't escaped that, and there's been a lot of debate as to whether construction sites should stay open simply because of their ability to follow the rules. There has been some site operating procedures that have been issued by the construction industry in terms of how to deal with, you know, things such as welfare supervision and social distancing. So have a look on their website. But I think construction will remain a bit of a hot topic in terms of what's classed as essential work, especially for those building the likes of the Nightingale hospitals at the moment, and whether that's classed as essential. But really, I think, you know, the PR pressure is as much of a driver for these businesses as the strict legal position. Some questions have a legal answer or a near legal answer, but the one big driver which should never be overlooked is how all of this plays out in public, whatever that legal position is. And we've probably seen in the press this week with the Holland and Barrett employees that are saying, you know, we shouldn't be working. There's been some noise about the Argos outlets within Sainsbury's stores remaining open for collections, which hasn't necessarily played well, and you could see that potentially. I'm not suggesting anything here as a sort of a bit of a cynical exploitation of the rules in terms of, do they really need to remain open? Then there's all of the warehouse workers delivering clothes and various other online orders that are being fulfilled, but certainly aren't essential fulfillments. You know, should that continue? There has been inspections of them by the council, who are satisfied that the law is being applied appropriately. But I think even if you do feel that you're applying the law appropriately, is how it all comes into play practically, and the issues that the press will make out of that, and how that may have an impact reputationally on the business, which are all things to consider. So a real state of flux. I appreciate it's difficult times. I think the key message is obviously keep speaking to each other and learning from each other and feeding in with all of the practical guidance. And then I think we've just got a couple of last slides that Hannah's going to talk through on Horizon. What's next?
Thanks, Hayley. Yeah, so I suppose as we've kind of just discussed, it's a bit difficult at the moment to kind of predict what's coming in the future, because kind of the true impact of coronavirus on how we live and work isn't really evident yet, and we're kind of working on kind of day by day, week by week at the moment. But pulled out a couple of points that might be interesting over the next couple of years to see how they develop and to be aware of. First one would be use of technology in health and safety, which is a topic I find really interesting. I've just put a few little points there on the slide, but I'm sure kind of most of you are probably starting to see the impacts of technology in health and safety management now, and will continue to do so. So the first one on there, virtual reality. So the use of virtual reality in training and risk assessing is a particularly kind of up and coming area. Kind of VR allows you to be able to like simulate dangerous situations as part of training exercises, to like kind of give employees and workers like kind of a more real life experience in terms of how to apply policies and procedures. It can also help a lot on construction sites as well, with sites that aren't built yet, to try and explain how things should be looking or should be running, or even predicting kind of what health and safety procedures you'll need to have in place when this site is at a more advanced stage. Wearable tech as well, the second point on there. So I think this one, I've read quite a few different bits about wearable tech helping to mitigate the risks of lone working. So obviously kind of like having sensors or wristbands that like are reporting back to a central log that can alert somebody monitoring it if there's any problems. I also thought as well, like in a kind of coronavirus sense, like they could help to ensure like safe distances between people in factories and in manufacturing plants. So that could be kind of a real-time application of the wearable tech uses. And there's even mobile devices for construction workers where it will notify the workers of their own fatigue, kind of by using a wrist sensor to kind of say that they need a break. So I think the industrial wearable market is set to grow. And I read a statistic recently that said it would grow to 2.25 billion by 2024. So that's quite sizable. As well as that, technology can be used to make accident reporting more dynamic and accessible. And AI can also be used as well to pick up on certain trends and predict where there's certain gaps might be perhaps in procedures that may lead to accidents. And kind of on the last point there as well, like AI can be used to help monitor PPE. So we're starting to see like kind of AI kind of checking or like facial recognition as well, checking the PPE that people are wearing and being able to flag when there's a problem. So really interesting developments there, and the use of technology for health and safety to help mitigate and eliminate certain risks, but obviously also key to be aware of the risks that they will bring with them in addition, and consider those and risk assess those in the same way as you would kind of before they existed. So it's kind of looking at the way they change the business and how it works, and whether there are any residual risks that need to be dealt with from there, even though obviously they do sound like they take things forward quite a lot and in a good way, but it's still important not to overly rely on them and to still think about those risks. So that's that one. And then obviously, as we kind of mentioned earlier as well when I was talking through the Grenfell slides, over the next few years there's likely to be quite significant changes to the building control regulations. A few of the upcoming changes are listed on the slide. So there's going to be a new building regulator, which will be part of the HSE, which aimed will be to improve building safety standards and oversee kind of a more stringent regime of enforcement and kind of checking for higher risk buildings. And then there seems to be, with points 2 and 3, they're kind of joint almost in a move towards consolidating and clarifying the advice for building owners and people working on existing buildings. So covering that second point, the updated consolidated advice will cover topics such as fire doors, cladding, and then other fire suppression systems as well, to kind of make it easier to access and to distill guidance on all of these topics in one place. And then the final point, there's a consultation that the government are in the process of reviewing responses for in relation to the Future Homes Standard. So that's going to be introduced in 2025. And this consultation is the first of 2 stages about proposed changes to building regs. And this one mainly concerns efforts to simplify guidance documents. And yeah, so they're reviewing the responses at the moment, and we're waiting for the outcome. But I think building control regulations is going to be a big topic over the next that we'll see lots of developments in, and that takes us all the way through. So I think we're happy to answer any questions that have come up as we've been speaking, or anything else you'd like us to comment on. But yeah, thank you very much.
Lovely, thank you very much, Hannah. There's been 3 questions that have been posted. There's been 2 on RIDDOR. The first being, will the RIDDOR reporting of COVID-19 apply to workplaces outside of NHS healthcare testing labs? And the second one, the HSE have changed the RIDDOR guidance to report COVID-19 on reasonable evidence that it was exposed at work and a worker dies as a result of occupational exposure. So have they changed their approach on RIDDOR?
I think in terms of the first question about it applying to workplaces outside of the NHS, I think from my understanding is that the answer must be yes. I appreciate the examples are probably drafted to give the impression that they will apply to the NHS and laboratories where you're, perhaps trying to deal with the antibody to combat the virus. But certainly my understanding from what I've read is that the guidance doesn't limit it to those types of organisations. It can be outside if it fits that RIDDOR reporting criteria. The other question, sorry, I can't now see it on my, oh yes, about the reasonable evidence, sorry. Yes. Yes, exactly, it has to be reasonable evidence, and again, what is going to be reasonable in one case may differ from another. I think in an NHS frontline worker scenario, it's going to be much easier than, workers that contract it whilst working in an office or something like that, for example. I think with everybody now working at home, we're going to be in a different situation. But yeah, it has to be reasonable evidence. So you don't have to prove causation in terms of definitely did they contract it at work, but looking at the evidence. And again, I appreciate that's going to be difficult, and you're just going to have to assess it on a case-by-case basis if and when you're notified that a worker may have contracted it.
Okay. Last question. My understanding from the HSE this week was that they would still visit sites in response to reports by workers or the public of significant breaches and or of imminent danger.
Yeah, I think that's right. And they have said, the work that they can do, HSE has obviously got an obligation to its own inspectors to protect them. So work that they can do from home, they will do. Work that they simply can't do from home, which is responding to those fatalities or serious incidents, they will have to visit sites and do that. And what they've said is that if they do visit sites, or when they do visit sites, then they'll observe the social distancing rules and the measures that have been put in place by the government. That's the stance they're taking on that.
Okay, well, that's all the questions that we've had come through. Well, what can I say, but thank you very much, Hayley, Anna, for another great presentation. Every year you do these presentations for us, and we thank you very much for that. And thank you for being the first webinar presentation.
Yeah.
Hey.
Exciting.
So I hope everybody out there that's been listening and watching the slides has enjoyed the new experience. And I just thank Hayley and Anna again. We normally have a round of applause here, so can we have a virtual round of applause?
Oh.
That'd be brilliant. Lovely. Thank you.
Yeah, stay safe, everyone. Take care. Thank you.
Yeah, and that's my sentiments to everybody. Please take care, stay safe, and we will meet again. Thank you.